The vote.
The sacred right to vote.
Voting laws.
Mail-in voting.
The right to vote historically brings hot debates and contentious discussions. With that came controversy surrounding recent election results and numerous bills trying to regulate when and how citizens can vote.
The right to vote now is much more polarized as a political issue than has been historically.
This is what democracy looks like.
Understanding why voting rights have become so prominent requires a look back to the not-so-distant past. Before the Civil Rights Movement and the Voting Rights Act of 1965, African Americans faced extreme discrimination and disenfranchisement.
You know, after the passage of the 15th Amendment, where Blacks were given the right to vote, the South was ticked and mad. Black men had the right to vote, and the federal government sent federal troops into the South to protect them. With that, we had an increase in Black folks voting and Black elected officials. We had our first congressman, our first senators, our first congressional folks. And we're talking the 1800s. Once that ended with the election of Rutherford B. Hayes, the federal troops were taken out. There was intimidation. There were legal ways such as poll taxes, the literacy test, the character test. Although the need then in the 60s with Martin Luther King pushing for the right to vote. And so the Voting Rights Act of 1965 was instrumental then in putting protection back in the South to help Black folks vote.
One of the strongest protections in the Voting Rights Act comes in Sections 4 and 5, a core provision called the Preclearance Clause.
It said that some states and localities, those that had a history of discrimination, before they could implement new voting rules, they had to essentially seek permission from the federal government.
With that stipulation, states were and areas were under scrutiny and had to have equity, had to have equal processes.
They kind of knew which states had been discriminating. And so then they came up with a formula kind of reverse engineered.
Even as late as 2012, the rule for whether or not you were going to be covered by this was kind of your percentage of African American voters in 1964 and whether you had ever engaged in kind of intentionally discriminatory practices. The details are a little more specific, but that was the basic idea.
It is wrong, deadly wrong, to deny any of your fellow Americans the right to vote in this country.
This preclearance clause primarily applies to states in the South until the monumental U.S. Supreme Court case Shelby County versus Holder in 2013.
And the Supreme Court said that it is unconstitutional because it was based on a formula that was not current.
So what the court held was that this formula is no longer rationally connected to protecting voting rights in 2012 or 2013 because it's based on data from 1964. That incursion on equal sovereignty is no longer tolerated today, particularly with a formula that isn't rationally connected to current conditions.
The impact of this court ruling came quickly. States once prohibited from changing voting laws easily passed laws with lasting effects.
So on the very day the U.S. Supreme Court issued its opinion, Texas officials announced that they were going to implement a new redistricting map that a court had found would discriminate on the basis of race, as well as a new photo ID requirement.
And we know that changing and reducing polling places, that has an impact on voter turnout. It reduces voter turnout.
Well, disenfranchisement can happen in a lot of different ways. Gerrymandering of districts is a form of disfranchisement because by packing voters into one place or cracking districts, you can make it harder for people in that area to select people they really want to represent them.
Okay, so it makes it easier for the states to put in these regulations and these processes that make it more difficult for minorities to vote.
We know that in many states, race and party are highly correlated. So if you target Black voters, then you're also targeting Democrats, essentially.
People aren't really interested just about the changes for the changes, right? The big controversy is what are the consequences of those changes for how people vote, who votes, and the question everyone asks is like, well, does this change the outcome of elections?
Since the 2013 case, many attempts at national voting reform bills have appeared. Within the past year, the John Lewis Voting Rights Act and the Freedom to Vote Act have arrived in Congress.
These new voting laws, new voting bills, because none of them have become law, those are really important. And what they seek to do is to undo some of the damage done to the Voting Rights Act of 1965 by the Supreme Court's decision.
I do think that in a broader sense, Shelby County has led to the conversations about how to make our elections more inclusive and more convenient. But certainly there's a correlation in terms of the conversation that we're having as a country on all of these various aspects of our election processes.
That's really, really unlikely, I think, to ever pass in its current form. But I think the thing that people do wonder about is there a chance that these things would ever be broken up and kind of bargained separately? So one trade-off that was kind of in the discourse for some time is, should the Democratic Party be willing to allow there to be national voter ID requirements in exchange for ending partisan gerrymandering? Like try to force both parties to take something they don't like. So far there hasn't been a lot of movement on those kind of things, but I suspect if we see elements from HB 1 put into law at some point, it's going to be a lot short of changing the filibuster, and even then I don't know that this would pass.
The recent legislation has had some pretty lofty goals. The For the People Act includes 2 weeks of early voting, more transparency on campaign donors and financing, and automatic voter registration. If the House of Representatives passed the bill, chances in the current Senate would be slim. However, if Congress reached a bipartisan agreement, legislators would need to consider how to enact federal oversights of elections.
I think there's some room for compromise in terms of what actually makes sense and to calibrate the rules. And this is where we need to be really careful and bring in local election officials to be part of the debate. I mean, some of these ideas have negative consequences that we need to be aware of. You're going to have more voting opportunities, and that can only be a good thing. Now, we've got to figure out how to pay for it. We've got to figure out how to implement it properly. But having expanded voting opportunities, whether you're in a city or in a rural area, can only be a good thing for democracy, as long as we also have the proper safeguards for it.